Hey everybody, thank you so much for joining us again today. I am here with a really special guest and a very dear friend of mine. This is Jim Burch, and he owns a company called Easy Legal Planning. Jim has been my personal advisor for, gosh, probably the last, I don't know, over 10 years on all of my trusts and my LLCs and just legal docs. So I thought would be great to bring Jim on today to mainly talk about the importance of getting a trust set up. I work with a lot of home buyers and sellers, and when people are buying homes and they're establishing that asset, I think it's important that they understand how things work if they were to pass away, properties go into probate, and I don't think people understand so much that can happen, and then your family has that burden of trying to get it out of probate. So, Jim, tell us a little bit about you
You
and your
bet.
company and some of the services that you guys offer.
You bet. Well, thank you, Heather. I was going to say, as you know, you are one of my absolute favorites, and I'm always, again, talking you up one side and down the other because of what an amazing job you do. So, anyhow, thank you for having me on today. We're so appreciative for that. But yeah, so anyhow, I've been in this estate planning world for almost 20 years, and I feel like I'm getting old. As you can see, I'm starting like Grizzly Adams here, starting to get gray, and I'm like, oh man, we're getting old here. But
You
anyhow,
still look
well,
good.
hey, well, yeah, thank you with that. But oh my goodness. But yeah. So anyhow, we started Easy Legal Planning a little over 15 years ago. I initially started working at a local estate planning law firm in Salt Lake, and learned a whole lot about how trusts and wills and business planning, all that works, and the ins and outs. And then one of the main issues that kept coming up over and over is people would come in and they wanted to get their estate planning done and they needed to get it done, but when they heard the price tag, they ended up hightailing it right back out of the office going, you know what, I don't really want to be spending, somewhere. And again, keep in mind, this is 20 years ago. We started about $1,500 and went up to about $3,500, depending on the complexity of what they were wanting to do. And so a lot of people, around that $2,000-ish mark, for something very simple, and they were like, I want to do this, but again, it's a lot of money to come up with. So I kept thinking to myself, going, okay, there's got to be an easier way to do this where we can make it more cost effective for people.
Mm-hmm.
And so, I had learned so much about how like the doc prep worked and so on and so forth. And so I went to the attorneys and I was like, well, what if we took more of like an online approach and we educated people on what their options are and how it works? And I said, most people probably have a pretty good idea of what they want. And then we can just have you guys draft the documents. So that way the documents are still, state specific, drafted by attorneys, but we can just take you guys out of the equation of not having to explain anything. We're not taking your time and effort on, and their high costs of those hourly rates to do that. And they said, well, yeah, we can do that, but no one's going to do that. And again, keep in mind, 15 years ago, the internet was not what it is today. And so I was like, well, I'm going to give it a shot. Let's see what we can do. And because of our price point, we start at like $595. So that's for a full entire trust package is like $595. And again, we'll talk a little bit more about that later. But because of that price point, it just kind of took off, and people were like, hey, I can do that. I can afford that, but they're still getting the same end product. And so we've just kind of grown, and now we're in all 50 states. So that way we've got attorneys in all 50 states that draft all of our documents. So that way, wherever you're located, as long as you're here in the States, we can help you out with doing that. So that's a little bit of the history why, but the main idea behind that was we were trying to save people money. We wanted to give them and provide them a really good product, but just do it a little bit of a more cost-effective way. And so anyhow, we feel like we've accomplished that, and it's been fun. It's been lots of good stuff. But any questions on that?
No, I think, well, one thing you just mentioned is that you work in all 50 states. And I know that I've referred you to a lot of my real estate agent friends in different states because you also do the trusts, you do LLCs and S Corps and things like that. So, for investors, cutting out the attorney. I know when I established my business and I set up an S Corp, I paid a lot of money for that. And I actually met you right after. I've probably known you about 14 years. I met you right after, and I was like, oh man, I wish I would have met you before I just paid an attorney to do this for me. So,
right.
So just maybe touch on like all the services that you guys provide, and then maybe even talk a little bit about the difference between a trust and a will. because
Perfect.
I know that's really also a little bit confusing. So
Total. You hit the nail on the head. Honestly, that's the biggest question that people ask is they're like, what's the difference between a will and a trust? So we're going to hit on that. But going back to your initial question of what services do we provide, and again, obviously the trusts and wills and powers of attorney, that's a good
yeah,
portion of what we do. But then we also do the LLCs and corporations. So that way, we work with a lot of small business owners or people that have rentals or they're getting into the rental game and they want to make sure that asset is protected if one of their renters slipped and fell. And so we're creating these LLCs or entities to hold those properties. So that way, if one of their tenants did slip and fall, they've got some separation or some liability protection there. So that's certainly something that we do as well. And again, we do that in all 50 states with that. And just in reference cost wise, because I know people are probably that are listening are like, what's the cost of that? So we charge $300 to prepare either an LLC or a corporation. And then that does not include the state filing fees. And every state is unfortunately a little bit different. Some states are relatively cheap. Some states are a little bit more expensive, but normally if there was a client that was interested in that, we're very upfront with them. So they would essentially call in, we'll talk them through it and say, this is what the cost is to set up the LLC in Texas or in Florida or whatever. And we kind of just talk them through. So that way, before they hit the go button, they've got a very crystal clear picture as to what is this going to cost and what's this going to take to accomplish that. So anyhow, hopefully that gives you a little bit of on that. Okay, awesome. So let's talk about wills versus trusts, because honestly, this is the biggest question that everybody has. Is they're like, why do some people do wills and why do some people do trusts? Now, initially, the main thing that I always like to tell people is you think about pop culture. If you're watching movies, if you're watching TV shows, they almost always talk about wills. Very rarely do you ever hear them talking about trust. And so we as a society, as we're watching that and growing up, when somebody's talking about, hey, we need to get a will because if we die, we want to have all of our ducks lined up in a row. So we just kind of, over time have kind of grown up on that. So initially, if we're thinking about, well, I need to do some planning, we go, I need a will. So I literally, I hear that day in and day out, every single day, I need to get a will. And so we talk a little bit about that. And I'm like, well, are you familiar with how a will works and what it does? And they're like, well, I think so. And so let's talk a little bit about that, because there's three key components, whether you're setting up a will or whether you're setting up a trust. And what I mean by that is, if somebody was coming into this brand new and they said, I need to get my estate planning done, whether they do a will or whether they do a trust, they have to answer three questions. Number one is, if they die, who's going to be in charge of the money? And that could be an individual, it could be a couple, it could be really whomever they want. Now, one question that people always ask is, they go, could that be my children that act as the executor? And the answer is absolutely, as long as your children are over the age of 18. Because we actually, this morning, I was actually just dealing with a client that they named their two kids, and the kids are like 3 and 5. And I said, well, unfortunately, they can't be the executors at this point in time, because they can't legally sign anything. And so they obviously had to name somebody else. But that's the first decision that anyone has to decide and make, is who's going to be in charge of the money if they die. Okay. And again, just remembering that they have to be over the age of 18. The second thing is naming the beneficiaries. So whether you're doing a will or whether you're doing a trust, you're naming beneficiaries. Or in other words, where's the money going to go if you pass away? Now, most of the time, if it's a married couple, they'll say, well, if one of us dies, we want everything to go to the surviving spouse. If we both die, we want it to go to the kids or grandkids or church, charity, foundation, or it can be a combination of any or all of the above. But typically when we're planning with people, is we always want to have a plan A and a plan B, and sometimes even a plan C. And what I mean by that is a lot of times people go, well, if we both died, we just want the money going to our kids. And I'll say, great, that's no problem at all. But what if one of your kids had already died? What happens then? And they go, oh, well, I hadn't thought about that. And I'm like, well, do they have children? Like, do you have grandchildren? And they're like, oh yeah, we do have a grandchildren from that child. And then we simply ask them and say, well, if that child passed away, would you want that portion going on to your grandkids? And they're like, oh yeah, I didn't even know I could do that. And so that's kind of our plan B. And then plan C would be, well, what happens if you had a child that died and they didn't have children. So
Yeah.
there's no grandkids. What happens then? And a lot of times parents go, well, then I'd want that to go back to my surviving kids. Or sometimes they'll say, I'd want that to go to a church or charity or foundation or something along those lines. But that's the second key question that people have to answer is, where do I want the money to go? Now, there is one slight little variation that I want to talk about when with wills versus trusts.
Mm-hmm.
If somebody sets up just a complete standard will,
Mm-hmm.
when they're naming beneficiaries, if the husband and wife or the individual died, that money goes to those beneficiaries as long as those beneficiaries are of age, which is 18. And a
Okay.
lot of times parents go, oh no, I remember when I was 18,
Yeah.
and if my parents died and I got a big lump, they're like, I would have blown right through that. I wouldn't have spent
Yeah.
it very wisely, which is most, again, I can tell you the car I would have bought. Honestly, like when I was 18, I can tell you the car I would have bought if my parents passed away and I got a big chunk of money
Yep.
with doing that. But that's the issue with doing that is if you only have a standard will, the age is 18. And that's, a lot of people go, that's not really good at age. Well, whereas in a trust, you're in control of dictating that age. So you could say, well, if I pass away, yes, I want the money to go to my kids, but maybe not until they're 30 years old. And until they're 30, that money's managed for them, and the money's still there to help raise them and educate them and all those things. But that's a little variation between the trust and the will, and a lot of people really like that.
Well,
Were you
and
going to
the
ask a
other
question?
thing, yeah, I just want to make a comment, and you can comment to this, but because I've done the estate planning with you, and you can also divvy it out, like maybe you say when you're 30, you get 10%, when you're 35,
Yes.
you get another 20%. So you can, like, the thing I love about a trust is you can do everything and anything that you want, and be very specific, even by child, if you want to.
Right.
Or if you like what I did was I said if my whole family dies, including my kids, then I want my sisters to get this much money and then their kids to get this much
Yep.
money. And you can just get so specific with it, which
Right.
is amazing. So,
Right. And then thank you. I was going to say that perfect. Spot on with I'll leave it at that. That was perfect
yeah.
and very well said with that. So that's the second similarity between wills and trusts. And then the third similarity is appointing guardians for minor children. Now, obviously, this is only if you have children and they're under the age of 18, or if you have a disabled child.
Yeah.
Because sometimes people go, I do have a special needs child that they're over 18, but I have custody and guardianship of them because of, the disability. So that's another thing that you have to be very aware of, is just being able to name guardians that would step in to get custody of kids. So a lot of times when we take that approach and we tell people, well, when you're setting up a will or when you're setting up a trust, you're appointing who controls the money, where the money's going to go, and who gets custody of minor kids. And then people go, what's the difference? It sounds like they're identical, with doing that. And this is the part that I always like to make sure and spend a little bit of time on to make sure it's crystal clear, because there's one big difference between the will and the trust. And the big difference is this: wills take effect after death,
Mm-hmm.
and trusts are documents that take effect right now while you're still alive. And a lot of times that confuses people because they go, why do I need this done while I'm alive? I thought we were talking about how I'd want things to go if I die. So why do I need a trust that takes effect while I'm still alive? And the answer is your signature.
Mm-hmm.
Everything, and literally, I mean everything in the estate planning world revolves around signatures.
Mm-hmm.
And so what I always tell people is I go, think about this logically. Like if I wanted to go into my bank to withdraw some money today, no problem, because I'm alive to sign on the dotted line. So there's no issues at all. Or if I wanted to sell my house tomorrow, I would call you, and
Yes.
then would be able to sign on the deed, and there's no problem. But if something happened and I die, or my wife and I die, now we have a problem because we've lost our signatures and we can no longer sign those assets over to anybody. And that's why people go, well, isn't that why you do a will? And the answer is, well, remember, when does a will take effect? The will takes effect after my wife and I die. But that creates a problem, because if my wife and I are dead, we can't sign the deed of the house over to the executor that we've named in the will. So all of a sudden, if my wife and I died and our executor steps in and says, I'm supposed to sell the house, they go and try to sell the house, the title company is going to say, executor, I hate to tell you this, you're not on the title. The only the people that are on the title are Jim and his wife. And if they're dead, they can't sign the deed over to you. So you're going to have to go to court and go through probate so that the court can represent Jim and his wife.
Yeah.
So that's the issue. And that's why I always tell people everything revolves around your signatures. While you're alive, there's no issues. But if
Yeah.
you guys, if both spouses or an individual that wasn't married passed away, you lose your signature. And if you lose that signature, you can't sign your assets over to the executor. And that's what triggers the probate. And it just takes time and money. I mean, is probate the end of the world? No.
No.
Does it take time and money? Yes. And is it frustrating? Yes. So that's really kind of what we're trying to avoid. And that's why a lot of people go, well, how do you avoid that? And that's where the trust comes into play.
Yeah.
Now, remember, the trust, when you're structurally setting up a trust, it's very similar. You're pointing who controls the money, where the money goes, who gets custody of the kids. But remember, the key difference is the trust takes effect right now while you're alive and you still have your signature. So the whole idea behind setting up a trust is, let's not wait until you're dead to let the court transfer your assets. Let's set up the trust now while you're alive and you have your signature, and let's use that signature to move your assets into the trust right now. So you can actually sign the deed of your house and move it over into your trust, and you can sign bank accounts and life insurance. The trust can also be named as a beneficiary. So like on retirement accounts and life insurance, the trust can be a beneficiary. So that way, if something happened and a husband and wife or an individual, if they weren't married, passed away, then all of their financial institutions will release the money to the trust. And then whomever you've named as the quote unquote executor of the trust, they now step in and they're legally obligated to follow the rules. But now there's no need for the court to get involved because there's nothing for the court to transfer. Everything's already sitting in the trust. And that person that's been named as the executor of the trust now is legally obligated to follow those rules. So it just makes it really, really easy. And then kind of the point that you were saying, you can put those different types of rules where you can say, well, yeah, I want the money to go to my kids, but maybe I'm going to give them a little when they turn 21 and they can use that for schooling or whatever. And then maybe I'll give them a little more when they're 25, but then I'm saving the rest till they're 50 because I'm kidding when I say that, but some
kids shouldn't get the money till they're 50. Let's be honest.
It's so true. It's so true. You know, we had some clients, this was a while ago, but they said, we're going to set this up that our kids get the money at 65. And I was like, man, your kids are going to hate you. But they said, we want our kids to work hard. And then if they turn 65, I said, they're going to have a great retirement. Because they said, who knows what's going to happen with retirement then? And then all of a sudden I thought about it and I was like, maybe they're onto something there because that, anyhow, the point being, you can do whatever you want. And that's one of the big advantages. But just remember, the whole underlying tone of everything is, it revolves around signatures. Estate planning revolves around signatures. And what we're trying to do is we're trying to help people while they're alive and they still have that signature so that they can get all their ducks lined up in a row. So it makes it really easy for their loved ones when something does happen. Does that hopefully help? It's
so clear. And I will just say, just in my role, I mean, I've worked with a lot of people who have had to go through the probate process. And I know someone who actually lost the house in probate. So it's possible. It's just a messy process. So why put your family through that? And it's expensive. So, if you pay the price of doing a trust today, you're going to save them way more down the road without dealing with a probate. I mean, you just helped my mom and she fought me and fought me and fought me on the will. I bought her for Christmas, she got a trust. Right. Because I said, I'm sick and tired of arguing with you, Mom. It cannot be in a will. Just because I know I'm going to have to deal with the estate, right? So I wanted it to be set up properly. And again, it goes back to how specific you can be. And then the cost of it, I mean, really, it's an inexpensive investment to protect your family and protect their assets and your bank accounts and all of the things. And working with you over all the years, I mean, we've modified mine several times as you change in life. My kids are the little then, and they're not little anymore, so all of the things change. But I also like what you said, that you can appoint the guardianship, which I think is really important. A lot of people have children, so it's important to be really specific. Then you don't have to worry about fighting with family and things like that. So
I just remembered something, and I don't mean to cut you off, but I don't want to lose my train. Again, with me getting old, I start to lose my train of thought here, and I'll be off with that. But one question that people ask all the time is if they had a child with a how they handle that. Because what a lot of people don't understand or they don't recognize, that if they don't do any estate planning and they pass away and that child is going to become a beneficiary, well, when they receive that inheritance, it's going to forfeit their benefit, because the state and government's going to say, you just
Oh.
got an inheritance from your mom and dad, spend that money
Mm.
first, and then they have to reapply when that money is gone. And so if you ever have, like, if any of you that are listening have any kids with special needs where they're receiving any state or government assistance, or you think that down the road they may need state or government assistance, what we would do is we would set up in the language of the trust a special needs trust for that child. So that way, if mom and dad, or if you're an individual, if you pass away, that money doesn't just automatically go to that child with special needs and forfeit their benefit. It's held in a special needs trust managed by one of the other kids or somebody else, and that money's there to then supplement what they're receiving. So that way, it still protects and lets them get their their assistance, but then there's still money set aside to assist and help them with things that are above and beyond what their state or government assistance would cover. So I was thinking
That's
about that.
important. Yeah, I
Yeah,
didn't
it's
know
an
that.
important
So
thing. Yeah.
that's really important to know. So
Yeah, so that's a good thing. There was something else that all of a sudden I was thinking about, and honestly, I'm like, what is happening to me here? This coronavirus, this whole COVID-19, the trapped. I'm like, what is happening here with that? Oh, I remember now. Now that I said that, the stimulus package. We've had so many people as of late that have been utilizing that money from the stimulus package
mhm.
to be able to pay for, because again, this is not a very fun
Oh
thing
yeah,
to, let's be
yeah,
honest, it's not a fun thing to buy. Like, a lot of people are like, hey, I'd rather go buy a TV, because often,
yeah,
again, you get benefit, you're looking at that, whereas this is like an awesome stack of papers. But a lot of people are using that stimulus money because they're like, you know what, I just got some extra money, and that way it doesn't feel like it's coming out of, even though it is, I mean, it's not coming directly like out of their
yeah.
hard-earned cash with doing that. So again, let us know if you have questions. Just let us know. And I guess what we can do as well, as you're sending this out, you feel
Mhm.
free to put my contact information,
Yes,
give my
actually,
phone number, my,
why don't you give it to us? And
yeah,
I just want to say, I reach out to you all the time for guidance and advice, and I refer people to you for guidance and advice. You're so good at talking through those things before someone even makes that investment. So, so tell everybody how they can find you, and
you
you
bet.
do a consultation call where they can get on the phone and kind of just ask you the questions that they have to make sure that they're
Yeah,
making the right decision that is right for them before they
right.
have to like commit to the investment. So I'll let
Absolutely. Yep, absolutely with that. So the easiest way to do that is, again, calling me or emailing me.
you.
And then what we'll do is we'll just schedule a time, and then we'll just have a one-on-one. We'll have a one-on-one and just kind of talk through, questions and options and so on and so forth. But my direct phone number is area code 801-656-7137. So 801-656-7137. And then my email address is Jim, so Jim at easylegalplanning.com. And easy is spelled out EASY. Sometimes people do the E and then the Z.
Oh,
And so anyhow, it's EASY, so easylegalplanning on .com. So Jim at easylegalplanning is that. So
and you have a
that's
website? Do you have a website?
yeah, so yeah, just easylegalplanning.com. And again, it has some, we've tried to take a very complex topic like estate
Mhm,
planning and make it very, very easy. And
mhm.
so on our website, we've got some of those animation videos that
Yeah.
you watch the person draw, and it just gives that, it's really easy to kind of follow the bouncing ball as to what needs to happen. So yeah, feel free to go on there, watch the videos, and then once you've watched the videos, it says you can either start the question, like if you're ready to go and you're gung-ho, you can start the questionnaire and you can start to fill it out online, or right below that it says schedule an appointment, and that's with me. So you just click on that, you find a day and time that works for you, and I'll call you on that day and time on the nose, and we'll have a conversation and see if it's a good fit for you. So
You're the best. I appreciate you doing this so much and explaining it. You take a complex topic and you make it very simple, and that's what I love
well,
about you. So
well, thank you.
So I appreciate you taking the time to do this, and I hope you stay well amidst everything. And
I know. I should have my mat. No, I'm just kidding. No, I'm
yeah,
used to saying
you're
everything
just supposed
with
to not
masks.
touch your face, right? And
I
I
know.
keep itching my face and doing all
I'm
the
not
things.
kidding you. And that literally, I've been telling everybody that. And then I notice how much I touch my face.
Yes.
Like and that's one thing, literally. I was like, I'm going to grow this beard because I'm thinking, like, okay, don't touch my face. And this has been helping me to not touch my face because literally I'm always just like,
Yeah, we
doing
do.
whatever. So,
We
but
don't realize how
I
much
know.
like we put our fingers in our mouth or
Totally.
all the time.
Totally.
But again, thank you for doing this, and I'll be talking with you soon because I've got some
Okay.
questions. So I
No,
appreciate
absolutely.
you, and
Oh,
bye
thank
everybody.
you.
Have a good day.
Thanks so much, Heather.
Okay.